All right, we're good to go.
Wonderful. Well, good morning, everybody. Wonderful to be here with all of you, along with Steve and Sam. So today we're going to start off with we're calling it the first of our series around this employment law change for 2024. There's a number of things happening. And so the way we decided to divide it up is we're going to start today talking about pre-employment. So we're talking more about some of the things that may impact or affect your things that you're doing before you hire someone, deciding if they should be a contractor or an employee, being able to share what the wage range is and so forth. So we're going to cover off matters related to pre-employment, and then we're going to have two more webinars coming up before October 1st, where many of them go into effect. Next up, we'll be talking about during employment, and then we'll be talking about post-employment. So if you are keeping up or have heard of other things and you don't see it today, it's probably falling into one of those other buckets, but please feel free to use the chat. We're here to help. So we're first going to start off. You saw this slide. This is the three of us. We're going to go ahead and introduce ourselves first after I just touch on this brief agenda. So as Mark mentioned, I think the only other thing I would add is that, we really want to make sure we help you answer your questions. And the three of us are all here local and happy to help with any of your matters. We recognize that many of the things that you may encounter are not always hard and fast, meaning that they make perfect sense. You might have more things that you'd want to understand better, and that's essentially what the three of us do in our respective areas. So our goal for today is we want to provide you with a high-level summary. We would be here for a very long time if we tried to go into all the details. So the intention is that we're really trying to give you an awareness, right? One, we want to make sure that you know these things exist. We want you to have a little bit of information so you can be, I'll call it dangerous with it, so you at least know. And we want to make sure that you are informed and have a way and a resource, which is essentially why the three of us are here, so that if you need help, you know where to get it. So a couple reminders. The first thing, we're talking mostly majority about Maryland specific employment laws. There are some federal laws that have changed. He's also going to talk about a few that, are we're waiting for some final determination, some things that might change. The world is ever changing, as we all know. And so one of the things that we just want to mention is our focus is around Maryland. We will touch on a couple of neighboring places, including Montgomery County. So if you do business there, we have a little bit of an update on that side. It's never a substitute for legal advice. So again, remember that we're giving you general advice, and whatever may impact your business, depending on the number of employees you may have, type of business you are, there's always factors that may make anything we share with you a little bit different for you. And the one that I'm most passionate about is reminding small businesses that they are not exempt from knowing the laws and following them. So one of the things I've been encountering in my practice in particular is that many small businesses first believe that, oh, those things probably don't impact me. I'm a small business, or I probably don't have enough employees for that to count. And we really want people to understand that that's not the case. And as Steve knows in particular, when things get to his desk, you're in a place where it becomes a problem. And so we're in the business of trying to prevent that. So that's where Sam and I can speak to it as well. So moving right along, I will go ahead and just start a little bit about myself before handing it over to my other great colleagues here. So I started PeopleRise in Severna Park about 2 years ago after an HR career. Excuse me. My focus is around strategic advisory. So I'm going to be focusing on your long-term plans and goals, ways that you can really infuse growth through your people. So a lot of my clients are looking to be in growth mode. They have multiple locations coming online. They're looking to grow their business. And also I work with business leaders around executive coaching. So it's a hard thing to be a business owner or a leader of a business. And a lot of times you also want to get a safe place to work out your thoughts and what you're faced with. And that's also where I specialize. A few core services that I mentioned, including retained search. So those of you that are struggling in the recruitment area, this is an area I do a lot of consulting on right now. We're talking about how to get qualified candidates, and also what are some ways that you can really showcase yourself as an employer of choice, so that instead of you always struggling to find people, the people are actually coming to you. I'm going to hand it over next. Sam.
Thank you, Susan. Hi, everyone, and thanks again for joining us today. My name is Sam Smith, and I'm the founder of People Operations Partners. We're a human resources and payroll consulting firm working with small and medium-sized businesses to kind of help them establish a solid framework and set them up for success in the HR and payroll space. Our clients come from a number of different industries, from brick and mortar businesses in the construction and retail space to online coaching and e-commerce businesses. We work with businesses that have little or no HR support, as well as those that have a small team but need added high-level support. Some of our services include fractional human resources and payroll management, payroll and HRIS implementations, and HR audits. And we assist our clients with various other HR needs. I would say another way we assist our clients is to ensure they remain compliant by keeping them abreast of ever-changing local, state, and federal regulations to keep them out of some of the sticky legal situations in which they may be required to call an attorney. We very much advise our clients to proactively work with employment attorneys, for positive, proactive reasons like employment agreements and reviewing your handbook. So with that, I'm excited to be here with you today, and I will pass it along to Stephen for his introduction.
Good morning, folks. Well, I am a partner with MDSW here in town. My focus is employment law, business counseling, and sort of bet the company litigation at the end of the day. My firm handles all aspects of the business life cycle. Like I said, I focus pretty much on the employment law stuff. My stuff's on there. You can see what it is. You can always find more information about me on my website. But one of the things I want you guys to really get out of this meeting is that an ounce of prevention is worth a pound of cure. And that's getting with Sam, getting with Susan, working on your policies and everything, and the information you hear today, so that you know, as much as I love putting food on my kids' table, you don't have to call me about, you know, certain things as they pop up. But inevitably, the employment law world is one of your greatest risks as a business owner. And so it's the three of our, you know, roles to ensure that we can protect you from even getting a demand letter or a lawsuit filed. And if they do happen, then we can, you know, defend you in those moments. So the goal here is pay attention to the new things that are coming up, paying attention to the opportunities, take those first steps to make sure that your business is protected, because it's just worth its weight in gold for you. So with all of that, let's jump right into the content. And as we're going through this, pop your questions in the chat bar and we'll go from there.
Great. So let me just summarize what we're going to cover today. So between Sam, Steve, and myself, we're going to chat through some of these changes as we go forward. So again, we're in the pre-employment phase right now. So we're going to be talking about salary posting requirements and some changes to Montgomery County's minimum wage. So if you do business there, have employees that are doing work there, things that you need to be aware of. I think this is one of the most substantial changes, and so Sam's going to do a great job explaining that. Steve's going to take us through the Equal Pay for Equal Work Act. What is that? What does that mean? I'll be talking about military spouses and military status. This is also an interesting one. I think many, especially given our Naval Academy and Navy partners in our local area as well, this is going to be an important one to be aware of. Then we're going to talk and touch on a federal law, which is about contractors and employees. And this is a really hot one because we know as a small business, it can be very hard to keep your costs low. And once you start hiring employees and all of that. But this is one where we all three agree that we need to be really aware, because we see folks every day who are putting people as contractors inaccurately. And that's a very big exposure point for your business. You probably heard a lot about non-competes, and Steve's going to take us through that, both at the federal level, so high level to better understand what that means. You've probably heard some buzz about it. And then in Maryland in particular, that we have one that's related to vet and healthcare professionals. So although I don't think we have anybody on the webinar today in maybe the vet space, these are going to be important things for you to at least know, because they may cover these groups now, but they may be coming for some of the others that you have. And then finally, I'm going to talk about the expansion of the Maryland Indoor Clean Act, and this relates to vaping and something that all of your businesses should be complying with today, regardless of how many people you have. So I'm going to hand it over to Sam to talk to us first about the salary posting. And one just quick edit is, certainly there's a lot of information on the slide and you can read it. We will give you the slides, but we'll do our best to summarize as we go through them. So Sam, over to you.
Thanks. Okay, so as Susan said, there's a lot to dig into here, but I'll keep it high level and make sure we hit the big points for you. As many of you already know, a few years ago, Maryland's Equal Pay Act was amended to require employers to provide a wage range for a position an applicant was applying to, but only upon that applicant's request. Maryland also has a salary history ban that took effect a few years ago, which states you cannot ask an applicant about their salary history that's on an application or in an interview until certain things occur. And if you learn an applicant's salary history, you can only use it to increase an offer. For a little bit of background information there. So effective October 1st, 2024, the law is amended to require you to provide a wage range, a description of benefits, and any additional compensation associated with the position. You must include this in any internal or external job postings, any solicitation intended to recruit applicants directly or indirectly through a third party like a recruiter or an agency, and it is your responsibility to ensure that your third parties are in compliance on this. The liability will be on you. If a posting for a position was not made available to an applicant, the employer must disclose the required information to the applicant before a discussion of compensation is held at any other time. At any other time the information is requested by the applicant. I know this is a bit of a change to the way people have traditionally done the hiring process. So definitely want to update your policies and procedures here and inform your teams as well. The law applies only to jobs that will be physically performed, at least in part, within the state. And the law defines wage range as the minimum and maximum hourly rate or salary for a position. So when you're thinking about the scale for your job posting, you want to consider any previously determined wage range for the position. I know a lot of us just don't have pay grades in place for our positions. So they have provided some different methods of kind of coming up with those wage ranges. They'll consider the wage range of an individual holding a comparable position or the budgeted amount that you have for the position. Employers are required to keep a record of compliance with the disclosure requirements as well for each position for at least 3 years after the position is filled, or if the position is not filled, 3 years after the position was initially posted. So this is, again, just getting your policies and procedures up to date. Mark had talked about a checklist and some of the items that will be on there to consider in preparing for this new legislation is determining which positions in your company may be performed, at least in part, in Maryland, and reviewing your hiring and pay practices, checking with those third parties, and also, very importantly, educating your teams on this, your recruiters, your hiring managers. And I guess while we are talking about wages here, we also wanted to take the opportunity to remind those of you who have employees in Montgomery County that the minimum wage increased on July 1st. Starting July 1st, the minimum wage rate for large employers, that's employers with 51 or more employees, increased by 45 cents to $17.15 per hour. while the minimum wage rate for mid-sized employers, that's employers with 11 to 50 employees, increased by 50 cents to a rate of $15.50 per hour. And the rate for small employers, that's 10 or fewer employees, remains at $15 per hour. So check your payroll systems and check your job postings for that. And our next topic will be equal pay.
All right. So one of the things that came out of the legislature this year is an expansion of how we compare employees and their compensation, and how we can't, I say we, but how employees can't be discriminated against based off of the traditional characteristics that they have on the basis of their wages or their compensation structure. Now, a lot of you guys who are sort of in the know here in employment law world will say, we weren't doing that before. Like, what? This isn't anything new to me. This is in addition to what you traditionally probably know about, Title VII saying thou shalt not discriminate in any terms and conditions of employment against the various, we call it the RCR SNO, the race, color, religion, national origin, sex, like those traditional characteristics you can't discriminate against under the federal law. And over the course of the decades, each Supreme Court has provided different, expansions of what those various terms mean. What's happened at the state level is that Maryland's legislature has always been much more progressive than the federal. What that means is that as far back as 1993 to 2000 to 2016, Maryland has been making changes to the different laws it has about how you can how you can or cannot make decisions and what you can factor into your decision making. And so what I mean by that is that the law will say that if you're factoring in race, religious beliefs, sexual orientation, disability into your compensation decisions, that's prohibited. Now, what's interesting about this law and this development is that last year there was a Maryland Supreme Court case that involved the Catholic, it was Catholic Church versus, or I'm sorry, it's like John Doe versus Catholic Charities or something along those lines. That case went through the differences between federal and state law and said, well, Maryland's Equal Pay Act, it just says sex and gender ID. It doesn't say gender preference or sexual orientation. So what that meant was that because Maryland had multiple laws defining what sex means in the context of these laws, it didn't mean that sexual orientation spurs from sex under this law. So what had happened was the court said, because the Maryland legislature didn't define it right, we're not going to extend the protection to this guy, John Doe in that case, and his sexual orientation issues with the Catholic Church. So Maryland legislature jumped on it. And if you can go to the next slide, you'll see the difference in the law. And so in the original law, it was simply, you can't discriminate based off of sex and gender. And for our purposes here, that doesn't include sexual orientation. So what it will be on October 1st will be the expansion to these other areas, to sex, sexual orientation, gender ID, religious beliefs, race, or disability. And again, what's significant about this is that it's the lawsuit that can be brought against your company is really what we're talking about. Because at the end of the day, if you discriminate against your employees against any of these protected characteristics, you're in trouble. If you do it in this context of compensation, the lawsuit is going to sue you for what the difference was between the plaintiff and the comparator. And what I mean is if I'm sitting there and I'm in my workplace and I have the same credentials as Jimmy Smith sitting on the other side, but Jimmy Smith is, Jewish and I'm Christian, and he's making $20,000 more than me because the boss is Jewish and he likes Jewish guys, I can sue the company for the delta between what Jimmy Smith is making and what I'm making times 2 plus attorney's fees. That's the delta. That's the difference between this and any other type of the discrimination laws, is that this has express remedies that make it a little bit more challenging for you when you hit that lawsuit. So the big takeaway from this is you need an objective framework for setting your compensation structures. And so that's where Sam and Susan comes into play, is to talk to them about what my onboarding looks like, what my payroll looks like over the course of time. Because as you're probably seeing, and as we heard when we opened this up, recruiting is tough and it goes through ebbs and flows, and inflation's high and then it's low. You're picking different things. Make sure that when you're picking different things and paying different people, that it doesn't, from a 30,000-foot view, look like you're paying people differently because of one of these highlighted protected characteristics. So that's my spiel on how this the expansion on the Equal Work Act has gone, or is going to go into effect. And now we're on to the next topic.
Thank you, Steve. So I'm going to be talking about hiring preferences for military spouses and some additional discrimination protections for military status. So as I mentioned, we have quite a military presence here. And so military status, as you can see here, is meaning a member of the uniformed services or reserves, or being a dependent of such member. And that was added to the list as protected characteristics. So it includes dependents of the member. So if you are a spouse, a child, or an individual whom the member has provided half of that person's support, and then you got the detail here about the preceding 180 days. These are folks that are covered underneath this, this law. And so as Steve also mentioned, Maryland continues to expand some of these areas. And so the anti-discrimination laws in Maryland continue to want to cover different groups of people, and that includes everything we just heard about: race, color, religion, etc. And now military status is added back in there, or added in there now. Genetic testing is in here. I mean, there's all sorts of things. And so I think the biggest thing here to understand is that you really want to make sure that whatever you have in place around how you pay, how you make decisions, and so forth, that you have some sort of guideline. I think we talk about in the HR world a lot of times around having guidance, right? Having a framework. And when you have a framework that allows you something that you lean against when you're trying to make decisions and as you do things. And so I think that's one of the most important key things as an employer, so that these things don't feel burdensome, but actually, you're just following the normal course of work with these types of considerations. The other piece around, let me just move to the next slide, around military status. This is also going to talk about military spouses. So interestingly, I have a few clients as well who have a lot of spouses who may trail with their service member, and there's now an addition where employers may grant a preference in hiring or promotion for the spouse of an active military member. And what's interesting about this is, spouses typically are trailing, they move often. And so a lot of where I think this came from was that a lot of times those military spouses are kind of disadvantaged, right? They may not be able to stay in employment much longer because they're moving around to different locations. Obviously with hybrid and even remote work in particular, that has changed. But for those that are doing work in a traditional, whether it's brick and mortar or in-person setting, this also can be a huge help. So this now means that Maryland law is allowing employers to grant a preference both in hiring and promotion to eligible veterans, and also people who are spouses of eligible veterans and active service members. And so I think that's pretty much the addition there. Steve, I was going to ask you to maybe build upon how you might recommend that employers provide a preference. What might be your perspective on what that could look like?
I mean, unless you have a spelled out express thing like you have here with military, I would certainly avoid the concept like the plague, because those, historically you'd hear it in the world of reverse discrimination. It's the non-traditionally discriminated against groups that'll come out of the woodwork when they see preferences in job advertisements or whatever the case may be. I think it's very difficult to utilize them. I think here what I would do, frankly, is, again, working with Susan or working with Sam when you're crafting your job posting, is that you are looking at it to say, okay, one, what is expressly what we're identifying as the preference? And I would almost cut and paste what Department of Labor says on it or what the statute says on it as your little block. So it can't be misinterpreted a different way. So for example, if, using a whole bunch of stereotypes, military spouses are only women. So you are creating a preference just for women in the way you've implemented your preference. Now, all of a sudden, you have a different problem in addition to just, what are the preference issues? Then it comes also into, if you have this preference, how are you actually going to use it? So whenever you hire the person, you're sitting there, are you saying, well, I'm just not going to entertain anybody who doesn't have the preference? Or if in the situation of the person who spoke at the beginning of this, you've got 13 qualified people and you've narrowed it down to the final 3, and it's just putting the thumb on the scale a little bit, or final 2, the thumb on the scale a little bit to say everything else is equal, but we have a preference based off of the statutorily permitted preference ability, then that's sort of how you can use it. But it is fraught with peril if you're just winging it. And that's where, again, my position is typically to avoid preferences because they can create the illusion or the suspicion of some form of discrimination. But if you're going to go ahead and do it, work with a consultant and make sure that everything is tightened up very cleanly and be able to document why you used it. Jimmy Smith and Jane Smith were great. One was a military spouse. That was the tiebreaker. Perfect. That's okay. Anyway. That's my spiel.
Thank you, Steve. I think those details are actually very helpful. And again, where you may hear about this generally today, but when you have questions about how that may come into play, this is again, what we're here to do, because it can be very confusing. So speaking of confusing, but hopefully help you a little bit get more clarity, I'm going to talk just a very small bit about contractor versus employee final rule. There is a lot on this area, but I think the most important thing that I've noticed is that many employers have in their mind what used to be the, I'll call it the testing for whether or not someone is a contractor versus employee. And so hearing people still use that old terminology, and I think one of the most important things here is that you hear these things have changed and that you need to be aware of them. I also see a lot of employers who are looking to bring people onto their business as contractors, and they are doing so many things. They talk like an employee, walk like an employee, even wearing shirts that identify them as working for that company. That is not what a contractor looks like. So I'm going to touch on this for a bit, and I'm going to let Steve also put in his great example. He talks about this example about when you were hiring a plumber. But so at a high level, there's something now called the totality of circumstances economic reality test. So a lot of words, but the reality is there are lots of factors that determine whether or not someone is a contractor or an employee. In the past, there seemed to be this weight around, how much decision-making responsibility did they have? Did they bring their own materials to work? Now what we're seeing is that there's 6 primary factors that these things have been revised. And also, right now, there's not just, a predetermined weight for any single factor. So it's not like, oh, if you do number 1, the opportunity for profit and loss depending on a managerial skill, and that's weighted 50%, well, then you are a contractor or you are an employee. Instead, there's a comprehensive evaluation of the worker status, meaning it's all kind of holistically together. I will tell you that more often than not, I have found that employers have employees, I'm going to even say in my experience only, probably 9 out of 10 times. But usually the reason that they are looking to keep employees, potential employees as contractors is because the person that is going to do the work has a preference. Oh, they want to be able to write off, whatever, or they want to, it's more advantageous for them. And I want to let them have that because why not? You're accepting responsibility for something like that, whether knowingly or unknowingly, and you don't want to be in that situation. And so what we really want to make sure here is that you understand there's a lot of detail to this. Again, just trying to bring your awareness to it, but no single factor is determinative. So unlike the way it used to be, as I mentioned, no one single factor is going to automatically determine whether or not somebody is a contractor or not. It's the overall economic dependence on the worker that needs to be ultimately considered. And that's where I go back to, you're in a really slippery slope if you are providing a lot of information for, or a lot of direction rather, to someone who's working for you. You'll see here even the degree of permanence. Does this person rely on you for work every single week? How much control? Are you the one finding the work? Do they even have a system in which they invoice you? I've seen people who are completing weekly timesheets and doing all the same things that a normal employee will do, but we write them as a 1099. These things are just not going to fly. And I think that we're going to see actually a lot of, I would say, audit and a lot of crackdown in this area, because this is a huge area and a huge loophole that also provides or takes away some of the taxes and other things that the government wants us to make sure that we're abiding by. But in particular for workers, it eliminates a lot of protections that they are required or should be receiving. And that's positive for employees, but also understand for employers, especially small businesses, this can be difficult, but the penalties are high and large. And so again, you don't want to be caught in that situation. It's much more advantageous to follow the rules and work with us to help you understand, how that may look and what ways in which you can get your business goals achieved, but also follow the law. Steve, can you give us your plumber example? I think it's a good.
Yeah, I mean, look, anytime you're doing this, you need to have, you always want to be looking for rules of thumb or something that jumps out in your brain and says, holy cow, I need to call my expert. And, so what I usually go to is I explain that, if you're looking to have somebody be an independent contractor for your business, think back to the last time your sink exploded or your bathroom backed up or whatever it was. You called a plumber, a guy who doesn't do the thing you do or has expertise that you don't, who comes out on his or her own time, brings his or her own tools, charges you a bill that they're going to hand you an invoice. They're going to go in there and tinker around and fix it. And then they're going to leave and you're going to give them a check for the bill or for the bill. That person is an independent contractor. They had their own stuff. They set their own time. They had their own opportunity to make it profit and loss. They invested in themselves. The permanence of the relationship is minimal. The degree of control is, again, you're pointing, fix that. That's your control level, right? You're not doing anything. And then they have their own skill and the extent the work is integral to your business. It's not integral to your operation of your house, right? It's not what you're doing. So if you can't look at that person and say, yeah, that looks just like the plumber I called the other day, you need to stop. You can probably still make it work. There might be ways that we can arrange it. Might be a marketing consultant, might be an HR consultant, right? Like there's worlds where that's okay, but you need to not treat it ho-humly. And this law here applies in the world of the Fair Labor Standard Act. So whether you have to pay overtime, minimum wage, et cetera, right? But there's another 20 or 30 of them that apply. And when Susan was talking about the audits and stuff, I call it the Holy Trinity. It's unemployment, workers' comp, and the comptroller's office of the state of Maryland. You piss off one of them, meaning one of your people who thought they were an employee, but you were treating them as a contractor, you fire them. They go to unemployment, they file. Unemployment doesn't have a record of them because you were treating them as a contractor. They send you a nastygram that says you screwed up. They also send a letter to comptroller's office to say, oh, I don't think you got paid your taxes because they didn't do this right. They also send it over to workers' comp who says, ooh, I don't think you paid the right workers' comp premium because you weren't treating them right. Then you get whacked. Do it right from the beginning and you don't get that problem. So just keep in mind, does it look like my plumber? If it doesn't, call one of us. We'll make sure you get it right.
Thank you. And there was a question in the chat about making the final determination who is considered a 1099 employee versus the W-2. The employer, and you correct me if I'm wrong, Steve, right? The employer is the one who's responsible for deciding.
Oh, 100%. Right? And remember, real fast, there is no such thing as a 1099 employee. Those are mutually exclusive concepts. Employee is a W-4 and they get what is W-9. I'm sorry. You fill out your W-4, you do your elections, you get your taxes withheld. That's the employee tax status. 1099 is independent contractor or miscellaneous income scenario. That's not an employee. So there's no such thing as that. So if you hear somebody come to you and saying that, this is not right.
Yeah, so we don't want to use the word employee. And we also, the thing I mentioned early on was I had a potential client who said, it's more preferable for the people who work for me to get 1099 so they can write off their mileage and this, that, and the other. It is not their decision, and they're not going to be the one responsible if you don't do it right and you get one of the things that Steve mentioned. It is something you want to really avoid. And so whatever thought you had around making those folks happy for the short term is going to cause a bigger problem for you and them. Steve, I'm going to hand it back to you for non-competes.
Yeah, so non-competes are a super hot and heavy issue that everybody's seeing, whether you're Maryland state only or whether you expand out into the world, crossing into interstate commerce. And so Maryland specific laws that they have on the books relate to, one, low wage workers. So if you make 150% of the minimum wage or less, can't have a non-compete. The numbers on that are like 46,000 and change per year. So if you're paying somebody that, they are not going to be subject to a non-compete. The other ones that have sort of played in over the years, and the most recent one we have here is healthcare and veterinarians. So healthcare, if you make $350,000 or less, and you are licensed by the state of Maryland to practice in your healthcare world, and it's direct patient interaction, you are no longer allowed to have non-competes with that particular individual. If they make 350 or more, you are, but it's limited to 1 year and 10 miles from the place in which they worked. That goes into effect July 1, 2025. If you're a licensed veterinarian, the non-compete dies as of June 1, 2024. And when I say dies, it means you just can't enforce it anymore. If there's anything before that, you can enforce that. But that's the sort of that's the demarcation line. That goes into effect now. So those are the things that we're dealing with. Now, when I say non-compete, I'm saying you can no longer tell those employees that they cannot do what they did for you, near you, for a period of time after they were employed by you. That doesn't mean you can't tell them they can't solicit your employees or your customers. That doesn't mean you can't stop them from using your trade secrets or confidential information. And that doesn't mean that you can't stop them from breaching fiduciary duties to you. That's the new wave of the future in terms of protecting your interests as a business owner. So whenever you have onboarding, you need to think, this employee is going to have access to my customer lists and all my contact information, or is going to be developing goodwill with my customers, or they're going to have access to all my confidential information and my trade secrets and the secret sauce as to how I make my business work. Those two things are what you have to look at. And in order to protect them, the non-compete is no longer a geographic. It's a, thou shalt not solicit my people, and thou shalt not use my confidential information. Those are the things that you're going to be thinking about when you're onboarding at the outset. These new laws that go into effect June 1 and July 1 of 2025 are going to be very hyper specific. But even if you have what we'll call low wage workers, that minimum wage keeps rising. So if you have folks who had non-competes or whatever the case may be, and let's say last year, you gave them a raise to $46,000, that's not going to be enough. If they have a non-compete now, it's void. So reconsider your wage thresholds when it comes to protecting your business. And sorry, there was one other thing. The FTC rule is everybody and their mother. When it comes right down to it, including independent contractors, no more non-competes, again, geographic non-competes. The status is that it is supposed to go into effect on September 4th. However, there is a lawsuit in the Northern District of Texas that is supposed to render a decision on whether the rule survives or not in August. So that is sort of the next time frame that we want to be looking at, is if that law goes into effect, one, you got to change the scope of how you protect your business. You have to proactively send notifications to the employee saying your geographic or your traditional non-compete is no longer enforceable. And that is something that you have to do on or before September 4th. It's my advice that you do not send that notice out until you have 100% confirmation that this rule is going forward, because it's a horrible place for you to be in if you told all your employees your non-competes are not enforceable anymore, only for that rule to die. So think about it, pay attention to it. Again, we're paying attention to the status of these cases. So whenever they hit, we'll know, we'll be able to distribute that information out to the groups.
So Stephen, as that's percolating its way through the course, we've got a question here about if someone had signed an NDA before the law went into effect, what's the status? Is that still enforced, or is that now no longer enforceable?
NDAs are great. NDAs are totally fine. That's sort of the point here. The traditional non-competes, you cannot work within this geographic area or for this subset of clients for a period of time after employment. Those are what die. But if you have an NDA that says, I'm going to show you the recipe to Pepsi so that you can help us grow our Pepsi brand and how it all works, or the tech or whatever it is, right? That NDA is still going to be enforceable. And that's the new wave of the future. You also have, in the NDA world, that is an essential step for creating trade secret protection. You must take reasonable and necessary efforts to protect your confidential information in order to get statutory or state and federal law protected trade secrets protection. So your NDA is still enforceable. It's not subject to these laws that we're talking about.
Okay, great.
Thank you. This is a very important and hot topic, and I think that will continue, as you mentioned, Steve. The three of us are watching it, and we'll be keeping ourselves up to date so we can share it. And then let me close with the last one. This is about the expansion of the Maryland Indoor Clean Air Act. I'm not sure if many of you know about this. This right now includes you can't smoke indoors. And so what's happening now is that vaping now adds to the list. So you can't smoke indoors and you can't vape indoors. I've seen this in so many cases. We were just talking about how people are bringing these into bars, they're bringing it into the grocery store. People are being very discreet about it in some ways, some people not so much. But the reality is you're not allowed to vape indoors starting July 1 in Maryland. And one of the things that we've got here is if you download this QR code, it'll take you, I created this and for anybody who would like to download a free printable sign. So actually at all public entrances, you are required to now post that vaping is not permitted. So smoking was already in place, but now they've added vaping to it. And in order to make sure that people know this, you need to post these signs. I have not seen any place as of yet, and we're what, July, I don't know, 17, 18, whatever day we are, mid-July, I have not seen one business in the state of Maryland who's posted this. So this goes back to what I was mentioning about regardless of the size of your business, you must comply. And these notices are not something that you want to, it's really not a big deal, right? You're going to print out this piece of paper, the sign, you're putting it up at your entrances, and you're making people aware. I doubt that you want folks doing this in your business anyway. And this is part of the reason why we need to make sure that these postings are put up and that we are keeping up to date and abreast of this, because if not, and if something occurs, your business can be responsible for those infractions. So free printable sign for you in this. And another thing for us to just keep aware, these things continue to expand. So now we're going to move to our Q&A with the remaining time that we have. And looks like we have a few things going on in the chat. I'll hand it back. Mark, maybe if you wanted to.
Yeah, let's to kind of get things started. How many of you all have 1099 contractor relationships in your business? Maybe just put in the chat yes, just so we get a sense of how many folks might be having to deal with that. So we got a couple, yeah. I mean, as discussed, it's an attractive thing for an employer to do in terms of trying to alleviate some taxes. It can be an attractive thing for the employee in terms of also some tax advantages too. So we've got a couple people, yes. So moving forward, you're going to have to take some steps to try and make sure that you're in compliance. Is anyone looking at hiring or bringing on a new 1099 contractor in the near future?
While people are answering that, I'll just say your different industries also have different things to think about when you come to 1099. So Maryland has what's called the Workplace Fraud Act that applies to landscaping and construction industries. And it takes that 6-part test we just talked about and basically shrinks it down to a 3-part test saying, do they perform work off premises? Do they perform work that's not integral to your operation? Or do they perform work unrelated to your business? And if you miss on one of those, they're going to presume the individual is an independent contractor. I'm sorry, is an employee versus an independent contractor. Further, for landscape and construction industries, you have to give an advance notice that the Department of Labor has spelled out as posted on their website of the status of employee versus independent contractor, well, I guess independent contractor notice, in order to be able to call them an independent contractor. And if you don't have that notice, again, the law presumes they're an employee. So there's other hiccups in your particular industries that you got to pay attention to whenever you are using, if at all, 1099s.
So a few extra steps there. Steve, maybe you can mention a little bit in terms of when someone's coming on in terms of documentation for the non-compete. What would some of our folks need to make sure, or what would they present a potential new hire?
So whenever and I'll put the notice in the chat, a link to the Workplace Fraud Act in the chat so you can see what they're talking about. But I just saw that comment pop up. But, when you have employees come in, you, again, are sort of identifying, one, are they an employee in a role that is going to have access to your confidential information? If that's the case, my preference is that you have a simple NDA or confidentiality agreement that protects the fact and highlights the fact that, one, the information is your property as the business owner. Two, you're giving them access to it as part of their job and that they're not to use it for or possess it for anything other than their job. And three, when they leave, they are required to give it all back to you and essentially certify that they've given it all back to you. Those are sort of the 3 components to this that you want to be able to have, the definition of what it is that they're doing and everything. And you want that in a document that they sign right then and there. And you want to do it for every single employee who has access to your confidential information. Because when I'm defending or advancing a trade secrets case, I'm looking very quickly to what were the efforts taken to protect your confidential information. And if you just said once along the way, don't disclose information you learned here, I don't know that that's going to be strong enough to get you there. The courts have said employee handbooks that have clear policies about your confidential information. Obviously, NDAs and confidentiality agreements are the key. Practices that narrow things down to only a few people are the types of things the courts are looking for. So whenever you're hiring the person, have them sign a confidential information non-disclosure agreement if they're going to have access to it. And then the other side of it is that they're going to be your salespeople, are going to have access to all your customer goodwill information. You probably need to have a non-solicitation agreement in place. Those are the restrictive covenant type things that you should have your employees sign when they start.
Right, some good advice as we move into the world of these new regs. Who has some other questions as we kind of reach the top of the hour here?
Mark, I was answering one in the chat that Jennifer posed, which I thought was a great one. She mentioned that they already have vaping covered in their code of conduct and was asking whether or not that was sufficient or to do the posting. My perspective is that posting always benefits you, right? It shows that you took the extra steps to ensure that the entrants were made aware. And having it part of your code of conduct is great because I would call it a best practice. You've got it in multiple places. But I think what we also, the 3 of us discussed as early as Monday, we were talking about how signage is very simple. And the idea of being able to make a sign posted where people enter, they're required to, people are able to see it. And so I think that is something that is simple and easy to do and only benefits you as the employer and of the public space. Sam or Steve, any builds on that?
I'm sorry, I was grabbing the link right as you were saying that last part. What that was, the having this information in your code of conduct?
Yeah, I think you just posted a link here.
Yeah, I'm sorry. Yeah, that link is to the workplace fraud act page from the Maryland Department of Labor, and it has an explanation of what it is you need to do, as well as their template notices in both English and Spanish. So it's very helpful information for you. But codes of conduct, I'll just say from a general perspective, if I have to challenge a claim for unemployment, or I have to explain why the termination is not discriminatory or otherwise retaliatory or some other thing, if I can point to a code of conduct that says it is part of our code of conduct that thou shalt not sleep at your desk, or thou shalt not do this, or thou shalt not do that, we are relying on an objective policy of the employer in making a decision that is non-discriminatory, and it is extraordinarily helpful. Unemployment, for example, will expressly say sleeping on the job, when you have a policy that says don't sleep on the job and you get fired for sleeping on the job, is a misconduct termination that disqualifies you from unemployment, which in turn presumably saves the employer on their unemployment premium percentage. So having a robust code of conduct can protect you in a multitude of ways.
And in this context, you're talking about with vaping, Steve, right? So if your code of conduct includes no smoking, no vaping, that's great. But we're also saying that posting these at the entrances, that they may not be, I don't know, maybe exclusive, right? That one doesn't mean you don't have to do the other.
Sure. Look, I think I heard you say before, you're never going to be hurt from posting stuff. Over posting saves your butt. I mean, I've literally had the site visit from the EEOC come in, and you get through everything, you show that you're right, and you've done all these things wonderfully, and he interviews all the people, finds out that you didn't do anything discriminatory, and then the investigator says, okay, well, now I want to go look at your posters, and a cold shiver goes down your back to say, boy, I hope these guys have their posters up. And we went back, and yeah, they did. It was great. It was good. But that's sort of the point, is your posters, put them up. There's no, this is one of those things that blows my mind if you just don't do it. Not doing it can trap you in extended statute of limitations, which means you can have larger damage claims in wage and hour cases. It might hurt you from the perspective of showing that you have disclosed your rights under the Title VII and things like that. All of that stuff hurts you or weighs negatively on you in the context of an audit, investigation, lawsuit, wherever the case may be. So if you have the opportunity to post it, post it. I just saw the question about posters. The Maryland Department of Labor has a whole chart. There's about a gazillion of them on there. Depending on what industry you're in, they have just about all of them. Susan has a great piece of recommendation, and I think Sam, you named the company in our conversation, but it doesn't hurt to get your hands on a company that is going to regularly update your posters for you. And that is, while you are still the one who's responsible, you're still the liable one if you mess it up. Having a company provide you with those updated posters is worth it.
Yeah.
And sorry, Susan, I was going to say there are a number of labor poster services out there, but I was also surprised at the number of businesses that missed that, the posting about not vaping. And I would say just subscribe to an HR newsletter. Susan and I both have newsletters. You'll get the updates via email. You'll know what's coming up. You'll know how to prepare yourself for these things, so you're not, working backwards and fighting them.
Yeah, absolutely. And one other maybe plug there is we also have other programs like Minerals. Sam and I both have experience working with that we can, whether it's you need handbook help, whether or not you want to get these alerts, you might do work in multiple states. How are you going to keep up with this information? And so this is where we can also help and steer you in the right direction. There's so much to cover, but our goal is to make sure that you don't feel overburdened with all this information, and actually, just adding another one of us into your expert toolbox of people to lean on, so that you can focus on your business, but also have awareness so that these things don't create distractions and other problems for you. The question about how to subscribe to the newsletters, we can do, I think, maybe a follow-up, Amy, that we talked about this. We're going to be able to send out something just to kind of share our information, and you can go ahead and subscribe to our newsletters. We'll send you the information to contact us, and you can sign up from there.
And that addresses Shardy's question too about contact information. So we'll be getting that out to you quickly.
Yeah. On Shardy's question, there's a lawsuit in, of course, the Northern District of Texas right now challenging the rule, but it is effective. And so right now you need to bump up your salary thresholds for the executive, professional, and administrative at a bare minimum. There's another one to that, but salary thresholds in order to get exempt from overtime. And then on January 1, 2025, it'll bump up to, I believe, $55,000 or $56,000 that the threshold needs to be. So as of right now, that's in effect. You need to audit your exemptions and make sure you're above the line.
And also, just to throw one more thing in there, I have so many clients who think that just because you pay someone a salary, it means they're exempt from overtime. Please, please review your job descriptions and the FLSA and work with us to ensure that you are properly classifying people.
Shardy, we can talk. I mean, one of the three, you're going to have our contact information. So if you'd like, I know I'm just saying this because we're 2 minutes over at this point. But you'll have our contact information, and we'll more than happily run through, sort of the next steps with the Fair Labor Standards Act's updated rule.
All right. Okay. This is we're at the top of the hour. A lot of information here, but again, a lot of it is preventive maintenance, if you will, putting some things in place in the onboarding process here, the pre-employment focus, which was this session. So we'll get this information back out to you. We are planning to have a second HR webinar in August, so stay tuned for that, and we'll kind of continue along the continuum of now we're trying to onboard, then after what happens when we hire. So that will kind of be the next focus that we'll be doing. So again, thank you for spending the time today. We were inside; it wasn't hot, so that was good. So any last words from our presenters before we sign off?
Nope, just always reach out. That's, again, the concept of an ounce of prevention is worth a pound of cure is hyper prevalent in the employment law world.
We're here to help.
So okay. And if our presenters can hang on for a minute once we wrap up here, that would be great. But anyway, everyone, thanks for attending. Look for the follow-up presentation and checklist, and also the next webinar. Have a great rest of the day and stay cool.
Thanks, everyone.
Everybody.
A good group. And got a couple folks still in the process of signing off. And I'm going to turn off the recording. I always forget that part. Recording, stop.